Good morning, everybody. Welcome to the First District Court of Appeals. We have several cases on our docket this morning. Only two will be argued, and the first that's going to be argued this morning is State of Ohio versus Andrew Lavender. I see Mr. Clark is here for appellant. Mr. Cumming is here for appellee. Mr. Clark, you'll have 15 minutes to argue this morning. Would you like to reserve any time in rebuttal?
Yes, please. I would like to reserve 3 minutes.
All right, I will keep your time for you, and whenever you're ready, you may begin.
Thank you. Good morning, Your Honors. May it please the court. I'm joined today by my co-counsel, Charlene Boland, off screen. The broad question before this court today about the necessary evidentiary burden before a hearing must be held on a post-conviction petition is hotly contested right now. Contrary to the state's argument that hearings are rarely needed, our jurisprudence is moving away from that argument towards a place where we will be holding hearings more routinely. We see that in two cases that are currently pending before the Supreme Court of Ohio, State versus Denny Blanton, about narrowing the application of res judicata and about narrowing a court of appeals ability to interpret facts that were not found by a trial court, as well as State versus Frank Lewis, which is about the appellate court evaluation of facts. Both of these cases—
So I appreciate your predictions about what the Supreme Court may do with that, but are you suggesting that we wait for those decisions?
No, I think that those cases are about a slowly shifting norm. This case illustrates why that norm needs to be shifted, because under the facts of Mr. Lavender, Drew Lavender's specific cases, where an evidentiary hearing should be held under any application of Ohio's post-conviction statute, it was not in this case. And dismissal of Drew's post-conviction petition without an evidentiary hearing has profound consequences for how we do justice. So I think that the way that this case was handled, combined with the assertion in the state's brief that post-conviction hearings are rarely necessary, this is the kind of case where a hearing would be necessary under a plain reading of the statute. We're moving in a direction where hearings will be more routinely held, I believe, but this case shows why that's a necessary shift in the law. The type of evidence that the state used to convict Drew Lavender is heavily correlated with wrongful convictions. To convict Drew, the jury had to credit an eyewitness identification and the testimony of an informant. Independently, these are two of the leading causes of wrongful convictions. Together, they amplify each other. So trial counsel in Drew's case had to find ways to investigate, to get into that echo chamber and explain and discredit why those pieces of evidence, which are so damaging in front of juries, had very little credibility. And the post-conviction investigation done for Drew demonstrates that the pre-trial investigation done before his trial, at which he was convicted of aggravated murder and sentenced to life in prison without parole as a teenage child, that pre-trial investigation was deficient. First, defense counsel's pre-trial investigation focused nearly exclusively on law enforcement failures. Second, the investigation necessary to challenge a life without parole sentence, which necessarily would have involved digging into Drew's life as a child, did not start until after the jury rendered its guilty verdict. And finally, a more holistic investigation into Drew's life, his family, and his community simply would have uncovered exonerating information.
I think what the state would say about your arguments is the concern is that you would allow anyone to kind of after the fact second guess the strategy and investigation done by defense counsel, and you enable kind of post-conviction proceedings to essentially be like phase 2 in the litigation. So what's your response to that?
That concern is not implicated with the specifics of this case. First, Drew's post-conviction, the 12 grounds for relief raised in it, very clearly attacked the pretrial investigation and not strategic decisions made at trial. And that's in accord with a long line of cases after Strickland versus Washington that say it's impossible to make strategic decisions about how to litigate a trial without doing an adequate investigation. And second, each of the claims is rooted in factually specific failures to trial counsel in this case. These are not generalized claims.
Let me ask you about a couple of those. Was there not an expert on eyewitness identification?
Yes, there was.
And there was not an expert on the functional size analysis, correct?
That's correct.
Has any appellate court dealt with functional size and its relevance? And if not, are you aware of any trial courts in the state of Ohio that have allowed an expert to testify on that issue?
I can answer both those questions, yes. So first, there was a post-conviction petition done in the Lucas County Court of Common Pleas where a functional size analysis was at the center of it. It's State of Ohio versus Xavier Matthews. That post-conviction petition was granted, but then the 6th District Court of Appeals overturned it, not on the merits, but because Xavier died pending the decision. So there is.
If it's not a widely accepted analysis, how could a court of appeals say that counsel was deficient for not presenting it?
I am not asking for a general rule that counsel always be deficient for failure to present this, nor am I asking for a general rule that an expert is always required in eyewitness identification cases. The specific circumstances of this investigation make his decision not to conduct a functional size analysis strategically unreasonable in this case. And here's why. So counsel did choose to hire an expert, Dr. Villano. Dr. Villano's report was riddled with factual errors that were exploited by the state at trial. And Dr. Villano also assumed the suggestiveness of the identification procedure in his expert report. So he didn't test it in any way. In response to Dr. Villano, the state hired Dr. John Wickstead. And Dr. Wickstead, who affidavits from trial counsel indicate intimidated Dr. Villano, was able to kind of pick apart his report and identify some of the sloppy areas of his report. And we're left in a situation where Dr. Wickstead's report assumed, and every conclusion in that report assumed the fairness of the identification procedure. So we have a report that the defense counsel views as overwhelmingly negative, that's based upon an assumption of the fairness of a procedure. Defense counsel is then told, you can test the fairness of a procedure using the functional size analysis if you would like to. There were emails sent by Kerry Wood. We have an affidavit from Kerry Wood reflecting this. And it was also something that was commonly taught in CLEs in Hamilton County, as the affidavit from Bill Gallagher represents. So in those specific circumstances where this one test, which cost only $85, could have been used to undercut a key assumption in a report that trial counsel viewed as devastating, the failure to do the analysis in this case was deficient. So I agree that there's not a lot of reported law about this kind of analysis, but the specific circumstances of this case where counsel already decided to go with an expert are what made the functional size analysis so important to Drew's case. And the attack on it, that it was anecdotal at best, is evidence in itself of why a hearing would be necessary if this court believes that that does establish the deficient performance prong of Strickland. Because this was a statistically significant test, and we could have an expert testify about how she conducted the analysis.
So your vision of the hearing is that all of the witnesses who attached affidavits, or most of them, would come in and testify along the lines of their affidavits and elaborate on them as necessary.
Yes, and specifically, not only the experts we had, but trial counsel as well. Each of Drew's trial attorneys, and he had 3 over the course of his litigation, did provide affidavits, but those affidavits, I think, to the extent that there's questions about whether a trial or an investigation strategy was deficient, there's a factual recitation of the broad bones of that investigation strategy in the affidavits. But certainly some of the conclusions that the trial court drew about this simply being a matter of trial strategy as opposed to a matter of investigation, I think that an evidentiary hearing at which trial counsel accounted for their decisions would be important. And most notably, I think among those decisions was the failure to speak to Duke Lavender. if you look at the state's trial theory in this case, the state of Ohio jumped in with both feet, I think that's the language from the opinion, on a teenage hitman theory in which Drew was simply part of the family business. The family business, according to the state, was the prior bad deeds of Michael Duke Lavender. Duke Lavender called Drew's trial attorneys from prison and said, I have something I need to tell you, but I can't tell you about it over jail phone. Jail phones are recorded. This is not the kind of thing that is a protected line. And Drew's lawyers never went to speak to him. They treated Drew's family simply as people with whom they could build rapport. They did not treat Drew's family as people who might have evidence relevant to either exonerating him or evidence related to mitigating his extreme sentence. And the fact that trial counsel simply failed to interview any of Drew's family, and then the state's theory at trial was, we know Drew did this because he comes from a bad family and was part of the family business, is simply inexcusable. And what would that conversation have gotten them on the question of guilt versus innocence? It would have provided a more nuanced understanding of the motivations of Domingo Johnston. Domingo Johnston was the state's informant in this case. Whenever he has a pending heroin charge, he provides information about a murder. Rodney Harris, Drew's trial counsel, went into depth about the more generic transactional nature of how informant testimony works. But we learned more about Domingo Johnston when we talked to Duke Lavender.
Mr. Clark, just a heads up, you have about 1 minute left if you want to reserve 3.
Thank you very much. What we learned is that Domingo had a longtime feud with Drew's family. So we have not just a motive to get out of trouble, we also have a motive to pin the trouble on someone else. And in a case where there were 2 judges on this court that would agree that the evidence here was not overwhelming. The majority opinion in his direct appeal said this was not a slam dunk conviction. And the dissenting opinion found that the errors in his trial were not harmless beyond a reasonable doubt. When we have that kind of evidentiary foundation underlying the initial conviction, and there's more.
Well, I guess that's my question. Do we use a different lens to review the propriety of whether an evidentiary hearing should be granted based on how strongly we view the evidence that led to the conviction?
On a Strickland standard, if we're looking, first of all, I think there's 2 answers to that. There's an abuse of discretion standard that's generally used when a trial court goes through robust findings of facts and conclusions of law. Here on that bare judgment entry denying the hearing, there's very little to review for abuse of discretion. You could look at this the way the 5th district looks at post-conviction petitions and say, we'll review factual findings under the manifest weight, we'll review conclusions of law de novo. But where there's relatively weak evidence to support a conviction, although the conviction was supported, and then the post-conviction identifies significant evidentiary failures that would have weakened the already weak evidence, I think that is relevant to the second prong of Strickland, and the question of whether there's a probability of a different outcome. Assuming that there's operative facts to conclude that, we're not asking for this court to overturn the conviction, we're simply asking for an evidentiary hearing at which we can more fully make this case. I would like to remain.
My question won't count against your time. You are at your time, but if the panel has questions, I'm going to let them ask, and it will not count against your 3 minutes. But if we agree that the court erred in finding that res judicata barred some of these arguments, isn't the remedy for us to send it back to the trial court to take a look at all of these issues that you're raising before us now, under the theory that the trial court didn't properly look at them in the first place?
We would gladly accept that remedy. At the same time, the court did make very, very barren factual findings, largely about the procedural history of the case, followed by a kind of broad conclusion that Drew simply is second-guessing trial strategy. And that, we would argue, misapprehends the nature of Drew's claims, which are not about the strategic choices made when in front of the jury, but are instead about the adequacy of the pretrial investigation. And assuming that that factual finding is enough, I do think it's appropriate to reverse and remand for an evidentiary hearing. If the court would reverse and remand on res judicata and say, evaluate this correctly before holding a hearing, we would be happy with that relief as well.
All right, any other questions from the panel before we turn it over to Mr. Cumming? Thank you. Mr. Cumming?
Yes, Your Honors. Good morning and thank you. To answer your question, I think directly right off the bat, Justice Bergeron, I would say this court should apply the standards set forth in State versus Perry and State versus Cole, unless and until the Supreme Court changes the standards. Those rules have worked well for decades. They basically prevent endless litigation. They preserve judicial resources. If we don't apply such rules, every trial could result in endless litigation and be sent back to the trial court to relitigate and review things that have already been decided or certainly could have been explored at trial. That's the essence of res judicata. Now, it can be defeated if a petitioner like Mr. Lavender attaches material, not just outside the record material, mind you, but material that's relevant, competent, and material in and of itself in the sense that it would make a difference. And I think the law has developed that when such material is appended to a petition that just really amounts to a different suggestions or different ways or different theories of how to do something, that's exactly the type of outside the record evidence that's not going to warrant an evidentiary hearing.
But isn't that, but I guess my question about what you just said is, by the virtue of a ineffective assistance claim, there's always got to be an element to counsel did something wrong, counsel failed to do something, and that resulted in prejudice. So there's always going to be, by necessity, some type of second guessing what happened in the trial proceeding, isn't there?
Oh, absolutely. It happens in every case. It's just that the law has grown
But
up.
how can we not consider that evidence for purposes of whether or not we should have a hearing?
Well, you can consider it. You can send it for a hearing if you determine that a fair exploration of his ineffective assistance of counsel claim requires it to be explored. It's the state's position here that Lavender's petition is the typical type of petition that it's clear on the face of it that a remand for a hearing is not required to fairly resolve the issues he raises. He doesn't raise issues of actual innocence. He doesn't raise issues of a new suspect or some unknown person that did this. Basically, if you take a bird's eye view of all of his claims, he's saying that the trial counsel should have investigated more extensively pre-trial. They should have humanized Lavender more for the jury. They should have challenged the array in a different manner. They should have impeached Johnson differently. They should have presented mitigation more organized way, perhaps explored Lavender's home and his situational community life. Counsel should have explained his texts better. They should have better prepared for sentencing. These are all typical examples of what the courts have always called second guessing. And these are the types of claims that do not warrant or require an evidentiary hearing. And I think just by straightforward application of the voluminous case law that's developed under Perry and Cole, that this is a very clear decision by the trial court that these issues were barred by res judicata or certainly otherwise not supported by material outside evidence. Now, Lavender did present outside evidence. I'm not saying he did not do that. What I'm saying is the evidence was not material in the sense that he had shown it would have made a difference if considered. For instance, the photo array, this court has already determined that it was not unduly suggestive. So to send this case back for relitigating whether or not a photo array analysis would have been beneficial is barred by res judicata. Just a very clear, simple application of that doctrine would bear out the trial court's decision that this is just.
What about the new evidence related to the informant, Johnson? Because Johnson's testimony was critical in the context of the conviction, and as we, as both the majority and the dissent noted in this case, it was a close question, and you have you know, a chronic informant who now we have evidence that he had some grievance against this family. Like, that seems worthy of exploring at a hearing, doesn't it?
Maybe in another case it would. I think in this case, the record would have struck us otherwise, simply because the reason Johnson was such an effective witness was simply because he volunteered to the police evidence that nobody would have known. It wasn't public information about the use of the revolver, and he just volunteered to the police that he knew that the defendant had a little small revolver, and that's not something that,
I mean, but that's not like, you know, I got his fingerprints on $100 bill that's here that's incriminating. I mean, that's a detail that anyone could guess at and potentially be right about.
well, I understand your point, but again, the bias of Johnson was explored at trial. It certainly was known about at trial. The defense's decision not to pursue it is quintessential trial tactic type of a decision.
Well, but I think that the disconnect here is part of his bias was explored, but there's a whole nother element of the bias that came out in the post-conviction that was not explored because counsel didn't know about it because they didn't do the investigation. I mean, I guess that's my question is, if we have a whole nother path here, why isn't that enough to get a hearing?
Well, I understand your question, and you're right. There's always going to be new evidence, another way to look at evidence, another path to explore that was unexplored. That's not enough, though. You need to show that this would have made a difference. Was it material? Would this truly have made a difference? Has Lavender met his burden of showing this court that discussing Johnson's feud with the brother was so important that had the jury just known that, a likely outcome would have been different? No, I think it's a very, very far cry for a court to be able to say, based on this record, that would be the case in Lavender's case. And I think that while you're right, it wasn't explored, there's always going to be a lot of things that were not explored. There's always going to be new tests, new principles of research that are going to be developed and discovered. But the limited resources of our court system does not allow us to relitigate these issues every time something new comes up. You have to have a minimum level of cogency and materiality before you grant an evidentiary hearing. It could have been explored. It wasn't explored. That's not the point. The point here is Lavender has to demonstrate to this court that it would have made a difference, and it could have been outcome determinative had it been explored. And he just hasn't made that demonstration here, Your Honor.
Mr. Cummins, let me ask you to jump to the sentencing portion, because the case law has said that for juvenile offenders, really a life without parole is equivalent to a death sentence. What do we do with the arguments that there should have been more mitigation, maybe a mitigation expert who dealt with some of the issues that are raised in the petition? What about that issue?
Well, I understand the seriousness of the issue. It's key, though, to note that there's no requirement that a finding of incorrigibility has to be made, and there's no minimum amount of mitigation specialists or evidence that has to be presented under any type of standard set by the Ohio Supreme Court. Obviously, in any case, somebody could always do more than what was done, and that is always going to be the case. But again, that's not going to entitle Mr. Lavender to a hearing unless this court is convinced that had the jury heard more about his background in the West End and his friends at school, it would have reached a different decision in the case, or the trial court would have. And I don't think you can make a showing in a case like this where the crime itself was so troubling. It was a murder for hire case, basically. And that is the type of case that gave the trial court pause here. And I don't think learning more about his school and his background and his friends would have made a difference. And I don't think Lavender's demonstrated that. Unless this court has any other questions, I think the record does support the trial court's findings here. I just will wrap up and say that Lavender's claim is number 1, 5, 6, 7, 8 and 9 through 12 were all barred by res judicata because they already were decided by this court, or he could have raised them at trial. The ineffective assistance of counsel claims fall into the category of those that are not supported by material outside evidence that justifies a hearing. And that's the conclusion I would leave the court with, unless it has any questions specifically.
Any other questions from the panel? All right. Thank you, Mr. Cumming.
Thank you.
Mr. Clark, you have your 3 minutes remaining.
Thank you. This was a troubling crime and a very long sentence for a teenager. And there are substantial questions about not just the length of his sentence, but about whether Drew was criminally culpable at all. Given those stakes, and given the level of granular detail in his affidavits, this is not the kind of case that's based on bare assertions that are put into affidavit form. The claims that Drew has raised about a functional size analysis, about an attack on informant testimony, about contextualizing his use of social media and text messages, because remember, he was a teenager in the West End. All of these things are not just throwaway second guesses at trial strategy. They point to fundamental failures in the pre-trial investigation of this case. We had attorneys who chose to attack the state's case primarily by attacking law enforcement procedures. That backfired in an enormous way at trial by allowing substantial testimony from Detective McNeil and his compatriot, Detective Garian, about why they investigate the way they do. But that could have been the best trial strategy after a full pre-trial investigation, had the pre-trial investigation prove fruitless in other avenues. The fact is, we know today that it wouldn't have. By doing a deeper investigation and some base level of, like, remember, there is case law from the Sixth Circuit that says defense counsel should be interviewing every witness who might have something to say about guilt or innocence. And we know that didn't happen here. And we also know that defense counsel's attack on the identification procedure, although it did involve an expert witness, was woefully inadequate once they chose that path. Once you choose the path to pursue an expert witness, you choose the path to adequately pursue what an expert witness might give you. And here they simply didn't. They got caught with a bad expert, they were given exit strategies, and rather than taking those exit strategies, they just pushed ahead and crossed their fingers. And in an LWOP case for a child, that is just not enough. I'm asking that the court remand for an evidentiary hearing so that we can build that record in testimony and give the trial court an opportunity to give Drew the trial that he deserves. If there are no further questions, I thank you for your time.
Any further questions? No. Thank you both for your arguments today. We will take the case under submission, give you a timely opinion. Thank you. And Ms. Hayden, if you will bring the next litigants into the courtroom.
Good morning.
Good morning. The next case on our docket this morning is Maurice versus Jim Collins Auto Body. Mr. Maurice, I know you are here representing yourself today.
Yes.
You will have 15 minutes to argue. And of that 15 minutes, you can save some time to answer whatever Mr. Becker argues, but you need to tell me ahead of time whether or not you want to save any of your 15 minutes, and I will keep track of the time.
Yes, please, Your Honor. So I can say 5 minutes, please.
5 minutes, all right.
Yes.
And Mr. Maurice, whenever you're ready, you may begin your argument.
Okay, Your Honor. It's me like a normal, regular human being, but well-educated individual. Do believe that the defendant's brief, for me, as a human being, doesn't logically make any sense. For two main reasons. It's just a repeat for what has been in the final order of the trial court, and a repeat of what's stated in the transcripts of this case. Also, he didn't answer any of my questions in my briefing that I submitted earlier. Number one, Your Honor, the Part 3A of the defendant brief, statement of fact, state of the case, shows three fundamental untruthful notes. Number one, per defendant brief, the defendant claimed that upon receipt of the vehicle, he explained plaintiff that a standard procedure is to tear down vehicle for re-inspection. First of all, Your Honor, this is absolutely untruthful, and it had never happened when the plaintiff dropped off his car there. Second, this note is quite against the defendant witness as indicated in the transcript, page 96, which supports the absolute untruthfulness of the defendant as
Mr. Maurice, if I could ask you a question.
Sure.
And so at the hearing on this matter, no one produced any evidence that they gave you a written estimate. Is that correct?
What? Can you explain your question?
Sure. Did the body shop ever give you a written estimate for?
I didn't get any written estimate. There is no contract at all between. It's just one oral communication between the defendant and me that if the insurance company didn't approve the repair and making the payment for you, I don't want anything to be done to the car. That was very clear from the very beginning. And that's the only communication between the defendant and myself at that time. And I repeated that more than 3 times. I told him, if the insurance company denied the claim for whatever the reason is, don't touch the car. I don't need any repair and I can drive it as is. Return the car to me. That's the only oral communication between him and I, and nothing else. Nothing written, anything else at all. Is that your question?
Yes, thank you.
You're welcome. Do I have to complete or?
You may keep going, yes.
Oh, okay. So, as indicated in transcript page 96, supports the absolute untruthfulness of the defendant as had never happened. Third, as indicated in transcript page 97, the same question had been asked before by the trial court judge to the defendant, and the defendant answer to this question indicated that this is not a standard procedure or even a part of the standard procedure. This witness quite indicative that this procedure is not basic at all, which is absolutely the inverse of what the defendant had indicated. Number fourth, the defendant ignored completely the inspection that it had been done personally by himself at the time of dropping off the car on August 25, 2020 afternoon, with an immediate charge fees of $25 per his shop regulations for the inspection. That's what happened in me. So this is number one false he did in his brief. Number two, he thought that he communicated with the auto insurance company in my behalf. It's not on my behalf at all, Your Honor, because if this was in my behalf, the insurance company would have never accepted to deal with him before, asking him to contact me to call the insurance company to communicate with, to tell them that he's the one first, or to tell him we need the approval from me, from the plaintiff. So this is absolutely incorrect, Your Honor. And what happened exactly? Is the fact of the matter is that the defendant was the one who proposed to me, the plaintiff, that he is the one who will communicate directly with auto insurance company, as this is his job for a long time, that he used to do for a long time, and he is quite aware of how to deal with them and handle the situation. For the plaintiff, as a regular human being, this is quite logic approach, since this direct mutual communication between the defendant and the auto insurance company will be 100% technical issues and purely work related, which I have no idea about, of course. Logically, this should have nothing to do with me in any way, with the plaintiff in any way. The defendant response to the forced assignment of error. First of all, the defendant assignment to the defendant response to. Let me go back again. Auto insurance company to tell that this is the defendant's assignment for the fourth assignment of error admits its correctness since it's factual issue. Then the plaintiff question here is how come the defendant didn't perform this legal fact, and how come the defendant asking to be overruled? Then, Your Honor, the defendant response to the sixth assignment of error is quite surprising to me as a plaintiff, as it obviously indicates the defendant's double measure thought, Your Honor. And astonishingly, the defendant claimed that the irrelevance of using external transportation to that critical matter. How come that he wants to overrule that? However, he didn't approach at all his fight for the nonsense parking fees when he asked for it. This particular matter demonstrates and indicates to me as a plaintiff a lot of purposely hidden mental and behavior approach matters in the current case as regard to the defendant brief. The defendant brief also, Your Honor, had neither handled nor antagonized any of the plenty of untruthful witnesses that he had made in front of the trial court. This is mostly what I want to say, Your Honor, and thank you, of course, for your attention and precious time. And all what I am hoping, Your Honor, is just to get my car back, because I have nothing to do. I'm living like a miserable life for almost more than 1 year now. That's all what I can say, Your Honor.
All right, Mr. Maurice, you will
Yes.
have 7 minutes left when it's your turn to argue again, because you didn't quite use up the 10 minutes. So you'll have 7 minutes to respond to Mr. Becker.
Okay.
Mr. Becker, go ahead whenever you're ready.
Okay. Yeah, I'm okay. I'm ready.
Thank you, Your
Mr.
Honor.
Maurice, just 1 minute. Mr. Maurice, if you will put yourself, do you know how to put yourself on mute for the moment while Mr. Becker is arguing?
The use what? Sorry, I'm sorry.
The mute button, and if not, that's okay.
Mute.
Yeah,
Mute.
never mind. Never mind. But
Okay.
Mr. Becker will be arguing now. Mr. Becker, you have 15 minutes.
Okay, the case is pretty straightforward. Mr. Maurice brought his vehicle to Jim Collins Auto Body Shop for repairs from a collision. He left it there with Mr. Collins, who was going to communicate with Mr. Maurice's insurance carrier on his behalf. In order to do an estimate, he needed to remove the front bumper to take photos of damage that you can't see without removing the bumper, provide those to the insurance carrier so they can produce an estimate. At some point after that, the insurance carrier contacted Mr. Collins and informed him that Mr. Maurice's coverage had lapsed. So no more work was done to the vehicle. Mr. Collins simply wanted compensated for his time of removing the bumper, taking photos, communicating with the insurance. And the trial court found competent, credible evidence that he held a garageman's lien, and without satisfying the lien, Mr. Maurice has no right to possession of the vehicle.
Let me ask you about the provision in the Ohio Administrative Code that Mr. Maurice references, which is that there must be a written estimate for any repairs or services
I believe he
when it's
referenced,
above $50, and there was no written estimate in this case. So why is that not a problem?
I believe in his brief, he referenced California Civil Code, not Ohio.
Well, I thought he referenced an Ohio Consumer Sales Practices Act.
He did reference Consumer Sales Practices Act in his brief, but that was never raised at trial court. He'd never mentioned that until now.
Okay. Well, okay. So I understand that point, but I guess my question is, if there's a provision in the administrative code that requires there to be a written estimate, and there was not a written estimate here, why is that not a problem?
Because in his lawsuit, he never alleged any Consumer Sales Practices Act violations. It was simply for replevin of the vehicle.
Okay, so there's no substantive defense to that. It's more just a procedural defense.
That's correct.
Okay.
I have nothing further unless there's more questions.
Any other questions from the panel?
For me, are you talking to me?
No, Mr. Maurice, now I'm talking to you. You have 7 minutes left. You may begin anytime.
Yes, actually, I have a lot of concern of what the defendant is saying. Number one, what the defendant did, it wasn't on my behalf. It was just a proposal because the insurance company didn't tell me anything and didn't tell him communicate out and didn't require him to call them first. This is number one in his talk. So it's not on my behalf. He did that out of his mind, and it was his proposal. This is number one. He talked about photos. He didn't provide any photos because I am the one who provided upon the communication of the auto insurance company, asking me to provide them with 64 photos for my entire car, particularly the damaged part. 64 images. So why they ask him for any photos more? I completely against what the lawyer said about this. Number three, he said that the unjust enrichment and trespass to chattel, it hasn't been in front of the trial court. This is completely wrong because it is making the transcripts, and I have transcript number. If you look at it, transcripts numbers being mentioned completely in front of its transcript. Oh my God, where is it? Transcript number, I think 104 and 105. It's being mentioned there. And he forgot completely about what the first case that I submitted to trial court for returning my car, the replevin case. It was all of it. It was about the unjust enrichment and trespass to chattel. It's all, the entire case was about that. So how come that he's saying that it wasn't in front of the trial court? I'm astonished. I'm really astonished of a lawyer to say that. How come a lawyer he's like ignoring all these facts? I don't understand. To be honest, I don't really understand. That's all that I can say about what he said. It doesn't make any sense because he's just repeating what he put in his brief. That's all what I can say. And all his brief is incorrect. It's completely incorrect. And a lot of lies in it, and a lot of like different mind working on it. I have no idea where he's coming from with his information. I don't know. That's all that I can say, Your Honor.
Right, Mr. Maurice, is there anything else that you would like to argue this morning, the few minutes that you have remaining?
Yes, I need my car back for unjust enrichment and trespass to chattel. That's my main, and this is the only car I have, and I don't see any place for the garageman lien law. In this case, I don't see that, absolutely not. He proposed it and it's been accepted by the trial court, which is completely inapplicable for this case. The only applicable law in this case is the unjust enrichment and trespass to chattel. That's my view, my simple viewpoint, although I'm not lawyer and I don't have any law background, but from reading and for all of that, that's all what I can say. These are the only two laws that can be applied for it, but the Garage-Manley law has no place at all in this case. And this is for, I can say for two simple reasons. Oh my God. Where did I put these reasons? I'm sorry. Yes. For two main reasons, it's completely irrelevant. For two main reasons, because the time operating statement to overcharged for complete work or service should be presented for this to happen. Number two, it should be 15 days after the work or services are completed, which had never happened because there's no work happened. Neither of these two conditions are existent. So I absolutely against applying this law to the case, to this case, Your Honor. That's for my simple understanding as a human being. I'm not a lawyer, I'm not a law person, but I'm talking out of my mind. I mean, I'm very well educated person, yes, and I have mind to understand, yes, and I can argue, yes, for what's right, what's wrong, but for laws and things like that, this is not me. That's all what I can say, Your Honor.
All right, Mr. Maurice, thank you very much for your argument today. Mr. Becker, thank you for your argument. We will take the case under submission and give you a timely decision. Again, thanks for your arguments, and this will conclude our arguments today for the First District